Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to another episode of Legal Ease, the show that converts legal jargon into legal ease. Now tonight we'll be discussing matters pertaining to family law. We'll be covering topics like marriage, maintenance, access, domestic violence. And it gives me great pleasure to welcome a guest that has appeared in season 1, a very senior attorney, Mahmood, who practices in Johannesburg. Mr. Mia has been an attorney since 1991 and has extensive experience in the field of family law. Mahmood, assalamu alaikum and welcome.
Wa alaikum assalam, Ashraf, and assalamu alaikum to all the viewers.
Mahmood, thank you for making yourself available tonight. When we talk of family law, it's a very wide area of the law, but obviously it deals with specific parts of what constitutes family law. Would be, like I said in the introduction, marriage. Now, how many kinds of marriages are there, or what regimes govern marriages in South Africa?
Well, in terms of South African law, if a person wants to get married, in essence, the person would, if he wants to get married in terms of the civil law, he would have a choice of choosing the appropriate regime. The first regime is that where the people get married in community of property. What this entails is that there is a kind of a joinder of the estates of the husband and the wife to be, and in essence, whatever is acquired during the course of the marriage would belong to both the husband and the wife. But as they share in the assets, they also are equally liable for all of the liabilities on an equal basis. Then the second kind of the regime is where a person chooses to get married by way of antenuptial contract. This is where prior to the marriage, the parties agree on the terms that's going to govern their marriage and what would happen upon the dissolution of the marriage, whether it's by way of divorce or by death. So in terms of an antenuptial contract, this is a notarial contract. One can by and large have any kind of term that one wants in there, provided it is not contrary to public policy. Mm-hmm. This is also the regime which is most closely associated with the Islamic Shariat marriage, where there is a total separation of estates between the husband and the wife. Then the third regime is actually a kind of a mixture of the ones that we mentioned, where one gets married with an antenuptial contract, but it includes the accrual system. So here basically there is a total separation of the estates between the husband and the wife, but at the time of the dissolution of the marriage, either by death or by divorce, mm-hmm. The parties' estates are revalued. When they get married, they place a certain value on their assets, and at the dissolution time, they do a revaluation, and any profit that is accrued during the course of the marriage, the spouse who has the lesser accrual has a right to share in the profit that is made by the spouse that has the higher accrual. Now, one mustn't confuse this with your normal nikah. In terms of South African law, if you get married just by normal nikah, that marriage is recognized for legal purposes. However, it doesn't have a proprietary consequence. So one can't say with any certainty that if I get married, or if I'm married only by Islamic Sharia, that my marriage, upon the marriage coming to an end, that I want the consequence of a marriage in community of property to apply. So therefore, what has been happening of recent is that there's been a strong move to encourage people to get married in terms of the civil law, and that is just basically to create some kind of certainty for the parties, so at least the parties would know that when the marriage comes to an end, they can expect, they would know what to expect at that particular time. Of recent as well, in terms from the perspective of the nikah, there are many alims now who are also registered marriage officers. So they can get people married in terms of Islamic Sharia, and at the same time, they can also have your marriage registered with the Department of Home Affairs.
So that basically gives it the force of a civil marriage. Before, there was a lot of confusion about whether Islamic marriages are recognized or not. So what you're saying is a registered marriage officer, and Maulana, is appointed by the Department of Home Affairs, and he'll celebrate that nikah, but it'll have the force of a civil marriage. Absolutely. And you'll obviously get a certificate of a civil marriage as well.
Yes, that is correct. The thing is that to be registered with the Department of Home Affairs, you have to comply with the legal formalities that pertain to a marriage. So as we mentioned, firstly, you must go to a person who is a qualified marriage officer. There are certain documents that you'd have to complete. There are certain formalities that are followed. And once all these are properly adhered to, then your marriage will be properly registered in terms of the civil law.
Now, like you mentioned, the recommendation is to obtain an antenuptial contract for the marriages that are nikahs that will be celebrated according to the civil law as well. But the recommendation is that you get a antenuptial contract signed. Now, how does one get an antenuptial contract? Do you just sign a contract between the two of you, or is there a special person that you go to?
Well, there is certain legal formalities as well that have to be complied with. This is a notarial document. In other words, it will have to be registered by a person who's a qualified notary. In terms of the content of the antenuptial contract, it is a contract where people have freedom of contractual rights, so they can agree on any terms. In fact, from the Muslim Lawyers Association, we are now in the process of assisting people where we're trying to create a kind of an antenuptial contract that will have a kind of a universal application, and it also would include terms that comply with the Shariat position. In its simplest form, an antenuptial contract would simply have some basic clauses to the effect that there is a total separation of the assets of the husband and the wife, that neither of them will be responsible for the debts of the other,
Right.
and that at the end of the marriage, either by death or divorce, that neither one of them would have any proprietary claim against the other. Now, in this contract, however, it is possible to stipulate, to say that certain things are going to happen in the course of the marriage. So it would not be unusual to say that during the course of the marriage, the husband agrees and undertakes to support the wife as well as any children that will be born from the marriage. One can even put a stipulation to say that if the marriage comes to an end, that the husband would give the wife a certain amount of money or property or whatever the case may be.
Right.
And one can also include Islamic terms. For example, from the Islamic point of view, the right of divorce vests only in the husband. But in terms of an antenuptial contract, it is possible that the husband could give this right to the wife as well. Obviously, there are certain caveats that we would put into place to ensure that if the wife is given these powers, that they are obviously exercised properly and in compliance with the Shariat position. So, as I mentioned, from the Muslim Lawyers Association point of view, we are trying to prepare this contract, which inshallah will have universal application then.
Well, I mean, it's quite interesting because it's quite a jump. What you're suggesting is there is a proper contract. Now, it's signed between the parties and the terms are agreed upon, and those terms are binding and they're effective at a particular time, more especially at the time of divorce. So for example, the woman retains the right to a divorce. Yes. So that's fasak, or she could have the khula. Those are the Sharia terms
that's correct,
that are appended to this. So it appears to be very, very complex, and I mean, it requires a particular skill. So in respect of the advice to the viewers, I think what you're saying is consult the right people.
Absolutely.
Make sure that you understand what joining of an estate means in respect of marriages in community of property. Let's just explain that a bit. What does it mean that there's a marriage in community of property?
What that entails is that basically there's a total joining of the parties' assets. So even if a party had acquired a fair amount of property or assets prior to the marriage, upon this marriage being concluded, all of those assets now form part of this joint estate. So each party would have an equal right to the joint estate, and by the same token, each party is liable for any debts incurred by that joint estate. Now, during the course of the marriage, your regime doesn't make too much of an impact. However, the real consequence really arises when the marriage comes to an end, either by death or by divorce. So, by way of illustration, if the parties are married in community of property, upon the marriage being terminated, the wife would be entitled to receive half of the entire estate, but by the same token, she's also then liable to pay half of all of the liabilities. Obviously, that only relates to all the proprietary consequences. The other aspects that arise from a marriage, which refers to the obligation to support a spouse or to support children, that is a matter which is not essentially governed by your actual regime. Those are extra consequences which flow from the dissolution of the marriage as well.
Now, I think it's very important that we also get to understand that when there's a joint community, both the spouses' estates are cemented together, and if one is a business person, for example, and his business fails, and his assets are attached, then everything in the joint estate goes. It's not that he can say, that half is my wife's, because it's an undivided share in the estate.
Absolutely. So when we speak of this joint estate, it means that when there is gain, then both are going to gain. But when there is a loss, then they both obviously would suffer the loss as well. So therefore, it's very important that when you are choosing your matrimonial regime, one needs to think of all of these particular aspects. Therefore, it is today, in my personal view, I think that it is prudent to always try and choose a regime that's going to give you protection of your assets, as well as give protection to that of your spouse. So from our perspective, I believe that to get married, the best possible marriage regime for me currently is that you get married with an anti-nuptial contract, excluding the accrual system. I think this gives both parties protection over their assets. It gives both parties the opportunity of creating their own separate assets. And I think it also protects each other's assets against any claim from third parties.
Right. I think that will be a convenient place to stop. We're going for a short ad break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. Now tonight we're discussing with my guest, Mr. Mahmood, an attorney in Johannesburg, family law. And family law, as we've heard, covers areas like marriages, interim protection orders, domestic violence, maintenance, and access. And you're reminded that the lines are now open for you to call should you have any questions, and the number is 011 086 77 00 1, 2, and 3, and the number appears on the screen, so you're welcome to call in. Remember, we were now talking about marriages and the different kinds of marriages. Now, obviously, there's also customary marriage, and that's governed by the Customary Marriages Act, and usually applies to African customary marriages and lobola and all of those issues. With regard to while the marriage is subsisting, and problems could arise, and usually those problems lead to either the attempt by the aggrieved party, it doesn't always have to be the wife, to apply for an interim protection order or a domestic violence order. Now, what is domestic violence, or what does the Act describe as domestic violence?
Well, firstly, we have the Act which is called the Domestic Violence Act. Now, it is an act which is very extensive, and I think that from my readings, actually in South Africa, we're quite fortunate to have an act that is so wide in its coverage. When we speak of domestic violence, it's not just confined to your conventional kind of physical abuse. The act is quite wide, and it says that it covers all acts, whether it's of a physical nature, emotional nature, psychological nature, economic nature. So if in any kind of relationship, and when we speak of a relationship here, Ashraf, we're speaking of any persons who are in a domestic relationship. Now, that doesn't necessarily mean that the parties are married to each other.
So that's an important distinction, yes, right? It's not necessary to be married to obtain a domestic violence order. We have a caller on the line. Caller, please go ahead.
Hello, assalamu alaikum.
Wa alaikum salam.
How are you?
Fine, and you?
Good, man. I've got two questions to the attorney there.
Yes.
My question is, I'm divorced, but what happened was my wife went to her lawyer to draw up the papers of divorce.
Yes.
Okay. between herself and a lawyer, they draw up a contract where she'll pay maintenance for the kids and school fees and like the madrasa fees, transport and so on, medical and so on.
Right.
But nothing happened ever since, you know. I've been taking all the expenses myself. Another thing is, because we were married in community of property,
Yes.
she took half my pension. But even that, she promised the kids that she'll use it towards the education of the kids. But nothing had materialized. Now, I spoke to someone else. They say, according to the law, if they break the breach of contract of not paying the maintenance, you can have them arrested. What I want to find out for you is, because, you know, mostly I'm talking about South African law and as far as Islamic law, and the basic fact is that 99.9% of women always get the benefit of the doubt, because when they get divorced, they always kind of blame the men. But did they ever sit and look at it with the woman is at fault and the man's got the kids and he's looking after the kids? And where does the maintenance story of that come in? Because I spoke to someone at the family court and
Right.
they told me I should follow it up with the attorney. But now the attorney had dropped the
Yes.
legal papers. I've left a message. She hasn't returned my call. I just want to know what the step. If you could give me advice, and maybe other brothers listening to this could maybe get more knowledge on this, because, you know, we as Muslims, we kind of shy away from our problems. So I thought, let me just put the question down. Maybe you could answer it to me directly and in general.
Thank you.
Jazakallah.
All right, thank you. Thanks for the question. So there's quite a few questions in that. Let's start with...
Okay, let's deal with the issue of the maintenance first. If there is a settlement agreement entered into between the parties, then that agreement will regulate, you know, which party must pay the maintenance. Now, people just need to understand that in terms of the law, the duty of support rests on both parents. So there isn't an issue to say that the husband or the wife is obliged to pay more towards the children. In terms of the law, there's a equal and reciprocal duty between both parents towards their children. So what the law says is that this duty rests on both parents, and each are obliged to contribute according to their means. So what we do is that we actually try and establish first what is the need in respect of the children. So if, for example, the reasonable need of the children is 1,000 rands a month, and if both the husband and the wife are earning equally, then each of them would have to contribute 500 rand each towards the expenses of the children.
Right.
Now, if there was an agreement entered into, if any one of the parties are not complying with that agreement can be enforced via the maintenance court. So if, for example, in this instance, if the wife had an obligation to pay maintenance, and if she's failing in that responsibility, then the husband needs to go to the maintenance court and basically open a complaint against the wife. She'll then be subpoenaed to attend court, an inquiry will be held, and then the court will obviously finally adjudicate on the matter.
So, Mahmood, what I think the caller was saying was that an attorney had drawn the document. What he didn't say to us whether that document was made an order of court. Now, let's say it's not made an order of court and there's an agreement between the parties to pay maintenance and one party is not paying. You still have the right to go to the maintenance court and request maintenance, right?
Yes, certainly. Yes. If parties are getting divorced, if they enter into an agreement, that agreement, to have the full effect of law, must be made an order of court. So at the time that the court is issuing a decree of divorce, the court is asked to make that agreement an order of court. Now, if the parties are separated and the parties enter into an agreement to regulate their relationship, that agreement is binding inter partes. So if there is a breach of that particular agreement, yes, the parties can either go to the maintenance court to enforce that. Right. Alternatively, they will also have remedies through the normal civil courts.
Right. Now, I just want to point out before we go to the next caller that the question of maintenance and access are two different things. You can't say, I can't have access because I'm not paying maintenance. Those are two different systems almost, and there's different laws governing it. I understand we have another call on the line. Caller, please go ahead.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum salam.
We are married in, can I say now, in a community of property,
yes.
Right? But now what I want to know, say now if I want to divorce and I want to get married in anti-nuptial contract, what will the cost be of that?
You want to divorce that same man and marry the same man by anti-nuptial contract?
Yes.
Now, divorce is not just going to court. There are very specific reasons that you have to give to the court. One of it is that the marriage has irretrievably broken down. So it's not like you can just go to court and say, I want to divorce because I want to change my matrimonial regime.
Okay.
That's a different application to court. Is that right, Mahmood?
Yes.
Yeah.
Now, the right procedure to follow is that one has a right to make an application to court for a change of your matrimonial regime. Now, obviously it is a bit expensive because this would you may have to bring the application either to the family court or to the high court. One would have to file affidavits and give the court reasons why. And then simultaneously with the application as well, you need to tell the court that you wish to enter into an antenuptial contract, and a draft of that antenuptial contract is also part of the court papers.
Yes.
And also of importance is that one would need to put an advert in the newspaper, and one would have to give notice to all of your creditors, because you see, if a person is changing their matrimonial regime, it has an effect on third parties as well. So the law won't allow you just to change it without giving due notice to your creditors and without them approving it. So that is the actual procedure to follow.
So for example, if the husband is a businessman and he's got creditors, those creditors need to know that he's changing his matrimonial regime. That means the assets are no longer the wife's and his. He could end up having zero. So that's the reason you have to give publication and notice and serve on all the creditors.
Okay.
You see, also the other thing, for example, is that if you currently own a home, because you are married in community of property, that property now belongs to both you and your husband.
That's right.
Yes,
yeah.
if you do convert to a marriage by antenuptial contract, excluding the accrual system, you can still maintain joint ownership. But if it is your intention that you want to transfer ownership to either one of the spouses, then that would obviously entail something further as well, because you now have to enter into an agreement with him regarding that particular asset, and then that asset would have to be physically be transferred, to the other spouse. So it's not a very simple matter. It is rather complicated. So I think you need to get good advice about it, and then basically see what assets you are, which assets you have, how you want those assets to be dealt with, and more specifically, how, if at all, it is going to impact upon third parties, more specifically your creditors.
And also, you can't tell the court a false story, because you have to give evidence under oath in a divorce that the marriage is finished. But thank you for your call. We have another caller.
So where can I go if I want to go in that way now? Where do I go to?
You need to consult with an attorney, and they will then be able to guide you along.
Okay,
So you must consult with an attorney in your area.
Okay, jazakallah.
Okay, you're welcome.
Assalamu rahmatullahi wa barakatuh.
Walaikum salam. We have another call on the line. Please go ahead. Okay, that call will come back now. So, Mahmood, what we were saying is during the matrimonial regime, there are various issues that arise, and part of that is solved by domestic violence interdicts and interim protection order. Now, you gave the different categories covered, mental, psychological, economic. You pointed out economic hardships that a party could be having. Now, on a practical basis, how do they do this? Where do they go?
Okay, basically in every area you have what is called a family court. In this court they would have a particular branch that deals with issues of domestic violence. So the Act sets out the procedure that has to be followed. In essence, you go to the appropriate branch, and then there are certain forms that you have to fill in, and together with those forms you have to complete an affidavit where you set out all the acts of domestic violence that are committed against you or that have been threatened against you. Once all the documents are completed, those documents are then placed before the magistrate, who will then consider it, and he will then determine as to whether there are grounds to issue an interdict immediately, or whether he wishes simply to give notice to the other party to attend court to put forward his side of the story, to thereafter enable the court to determine whether an interdict should be issued or not.
Now, let's say it's after hours now. Now, what do you do? Where do you go? Who do you call?
If it is after hours, unfortunately, our courts are not accessible 24 hours a day. So your first port of call would be to go to the local police. Now, normally, an act of domestic violence, in most cases, involves physical violence as well. So your first stop would be to go to the police station to open a charge of assault against the assailant. So that would give you immediate protection in the sense that the police then have a right to have the person arrested. You know, this act also is very helpful in the sense that once you report a matter of domestic violence to the police are obliged to assist the complainant by putting her into a place of safety. If that is not possible, then they need to take into custody the assailant to give protection to the person. If, however, it is not such a serious matter, they can then give notice to the person to attend court, you know, on the next court day.
Okay. We have another call on the line. Please go ahead.
Assalamu alaikum.
Alaikum salam.
I would like to know, my husband has been divorced for the past 17 years, and he would like to know what is the procedure of removing his ex-wife's name from the house.
That's a very interesting question.
Well, now, again, it depends as to how he was married. If he was married to her in community of property, then by operation of law, she would have acquired a half interest in the house. So if in terms of the divorce order, if, for example, they were married in community of property and the divorce order simply said division of the estate, what that would then mean is that he would have to purchase her half share to take transfer of it. If they were...
Sorry to interrupt, but it was stated in the divorce decree that it is his responsibility to remove her name.
Was there a court order? The starting point is, was there a court order?
Yes, there is a divorce decree.
Right. Now, in that court order, there'll be directions as to what will happen to the joint estate. So she and he both owned 50-50 in the house.
That's right.
But it'll say, listen to what what Mahmood is saying. It'll order division or it'll order something else to happen. So, am I right? The starting point of this is, let's look at the divorce decree.
Yes.
And then we can decide from there.
Did the divorce decree make any specific mention of the house, or did it simply say division of the joint estate?
It did specifically say that my husband is responsible for removing her name from the house.
So
Then
did the
it's
order
very
say,
easy.
Did the order say that he would be entitled to retain the house?
Yes,
in his
that's right.
entirety?
And he has already paid her out.
Oh, okay, that's fine.
A lump sum
So
of money.
you now need to go and see a conveyancer,
Right.
and you'd have to give them certified copies of the divorce order. If there was any obligation on him to have paid any money, they must show him proof of that particular payment. He will then prepare the appropriate documents to do the transfer of the half share into your husband, into your current husband's name. This entails an endorsement on the title deed. There is a cost involved for this, so I think you should go and consult with a conveyancer in this regard.
Okay, should we take the title deeds with us to the conveyancer?
Yes.
Yes.
Okay, tell me the rates and taxes, is that any concern?
Yes, if there is, in terms of the law now, to transfer property to another person, you need to obtain a rate clearance certificate from the local municipality. So if there is any arrears to effect this transfer, you're going to have to settle all those arrears. And normally the current protocol is that they charge you a 3 to 4 months in advance amount as well. So you'll have to pay all of that, and there will be a cost as well for the conveyancing.
Okay, Jazakallah so much.
Okay, you're welcome.
Assalamu alaikum.
Walaikum salam. And now it's time for another short break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight we're covering a very important topic of family law. The reminder to our viewers is that the lines are open and you have an opportunity to consult and call in, and the number is 011-086-7700-1203, and the number appears on the screen. Now, just before the break, Mr. Mia was explaining to us that in order to obtain a domestic violence order, certain processes have to be put into place. Remember, you were saying that there had to be an affidavit. We were talking about going to the police, or, okay, what happens now?
If you go to the domestic violence section, then they have a prescribed form which has to be completed. It is done on the basis of an affidavit, where one would have to explain all of the incidences that you've experienced or the threats that you're experiencing. This is then placed before a magistrate, and if on a prima facie basis they feel that there is grounds to issue a interdict, they will do so. what this entails is that the court would then give to you, as the complainant, the interdict together with a warrant of arrest. Now, this warrant of arrest will be used by you in the event of there being an infringement of this order. The order, however, first must be served on the person against whom you've laid the complaint. So you cannot enforce that warrant unless it is first served on him. And this is done via the South African Police Services. So once you receive the interdict, take that to the police, and together with the police go and have it served against the assailant. Once the documents are served on him, then that interdict comes into operation. And if there is any violation of the interdict, then all that the person needs to do is again go to the police to say that the person has breached the conditions of the interdict, and thereafter the police can act by either again having the person arrested or giving him notice to attend court for the matter to be further adjudicated upon.
Now, is it correct that you, if you are unable to go and make this order, can somebody else go on your behalf? Can an older person in the house, another family member, a neighbor, who can go and make this order for you?
In essence, the Act affords a right to any person who is interested in this situation. However, the only requirement is that even if an application is made by a third party, that the third party needs to obtain the consent of the complainant for bringing it. So, for example, if there is a minor child, that would be an exception. If there is some violence that is being committed against a minor child, any person can lay a complaint on behalf of the minor child, because the minor child does not have legal capacity, and to obtain that minor child's consent would not be a prerequisite. But if, for example, a person is suffering from some kind of a physical impediment, then that person can give the right to a third party to go and bring the application on their behalf. Now, people also need to understand that the issue of an interdict has got very far and wide-reaching consequences. Firstly, it's not limited in time. So that interdict will remain enforced until such time as it is set aside or it is altered by an order of court. So if an incident occurs today, that interdict will still be applicable even a year later or 2 years later, for that matter. So therefore, it is important that if someone has taken an interdict against you, and if you feel that there were not good grounds for it, then it's important that you then approach the court for relief to have that interdict set aside. Because if you don't do that, the person who has the interdict against you could possibly abuse that interdict to your detriment.
So what you're saying is the respondent has to be alert and he has to respond to these allegations, and if there's no truth in them, he should make sure that he attends and puts his version forward.
Absolutely.
Now, with regard to, let's say, evidence of the physical violence, is it necessary to go to a doctor to have it recorded, or must you take photographs, or what must you do in those circumstances?
It is important to always have some kind of evidence regarding injuries that you may have sustained. In this regard, you can go to the district surgeon, and there is a form that you can obtain from the police. It's called a J88 form. That is a form that will be completed by the medical practitioner, and that will be admissible as evidence under certain circumstances. But certainly, in terms of applying for the interdict, it will be some kind of prima facie proof to the court that you have sustained injury, and on this basis the court may be prompted to then give you the interdict that you are seeking.
Now let's say as a consequence of the domestic violence and all of these actions, now there's there's no prospect of reconciliation of this marriage. What happens then now? Can either party, let's say you're the innocent party, can you, as let's say the perpetrator, can you approach the court and say, no, I want a divorce? It doesn't matter that I have the domestic violence interdict against me. Is there any impediment for me to go to court?
No, there isn't. Well, the Domestic Violence Act deals specifically with issues of domestic violence. But if there are other issues that arise from this, for example, if there's issues of now supporting each other, that court could refer the matter to the maintenance court. If there is an issue of a divorce that would now arise, that would be dealt with by a separate forum altogether. Now, people also need to understand that in terms of this particular act, it could happen that a husband and wife are living in one house. Now there's an incidence of domestic violence. The court has got the power to even divide the house, to say that the husband, you have to confine yourself to certain parts of the house and the wife to certain parts of the house. Because it could often happen that in a case like this, that the spouse, the aggrieved spouse, does not have resources to move out of the house.
Right.
So that is also something which can happen. Now, while that interdict is in force, it is fully operational, and if then there is a need now to seek other relief in terms of maintenance or divorce, then that can be brought simultaneously while this interdict is in place.
So, in other words, there's no impediment to proceed with the divorce, even if you're not the aggrieved party. Even if you are, let's say, the guilty party, you can actually still proceed with an application for divorce. And then that is by way of summons.
That's correct.
Okay.
Now, as Ashraf had mentioned earlier in the program, that the primary requirement for claiming divorce is there must be an irretrievable breakdown of the marital relationship between the parties. So in terms of our law, either party, if they feel that the marriage has broken down, either party can actually institute divorce proceedings against the other. And this is done by way of a summons. In terms of our current court structures, one can either institute the action out of the local family court, which is the magistrates court, the regional division. Alternatively, you can do it out of the high court.
But it's recommended to go to the family court because it's inexpensive and the time period is shorter as opposed to the high court role.
Yes, I think also what has happened now is that the family courts have become very efficient, especially the one in Johannesburg. In fact, many people are now doing divorces on their own accord. They have people there who assist them. However, just exercise caution in this regard, because the people who assist you there are not qualified attorneys. Yes, they have got some knowledge, but certainly they are not qualified attorneys, and it's always prudent to seek proper legal advice in empowering yourself with what your rights and obligations are.
So what you're saying is a DIY. There's a DIY divorce, but still take the opportunity of going to an attorney and discussing. It's a very important step. We need to go for another short ad break, and I ask you to please stay tuned and join us after the break. Assalamu alaikum and welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight my guest is Mr. Mahmood, an attorney in Johannesburg, and we're discussing family law. Thus far we've discussed various marital regimes, what happens when there are difficulties in the marriage concerning violence and other threats, how to obtain an interim protection order, and basically now we're talking about the divorce and the process of divorce. We've heard that you can even do a DIY divorce if you go to the family advocates, the family court located at 15 Market Street in Johannesburg. And every other area has got a family court, and you need to find out. I understand we have a call on the line. Please go ahead.
Hello, Assalamu alaikum.
Walaikum salam.
My question is, if a man has more than one wife, one married under the old act and one under the new act, what happens to the estate?
Mahmood?
Sorry, what act are you referring to?
If a man has more than one wife.
Yeah. Okay, let's say, is the first marriage a civil marriage?
Yes.
Then the second marriage can't be a civil marriage.
A customary marriage.
A customary law applies to black marriages, marriages celebrated according to a particular black tribe or a custom. So the customary marriage doesn't extend to, I think your question is Muslim marriages.
Yes, Muslim marriage.
So if the first marriage, let's just take it in the following scenario, the first marriage is a nikah. The second marriage, you're asking if that can be a civil marriage. Alternatively, yes, the first marriage is a civil marriage. The second marriage you want to know, is that also a civil recognized marriage? Emma?
Yes. Yes. Can I listen off air?
Sure.
Thanks.
Currently, in terms of South African law, a person is not entitled to legally have more than one wife. In South Africa, if a person gets married to a second wife, that would be regarded as being a bigamous marriage. However, in terms of the situation where a person has got a second wife, there has been recent case law where our courts have recognized the right of that wife to also have a claim against the estate of her husband. Now, I think this also is not a directly related topic, but it's also important for people to know that if you do have more than one spouse, then it's important to then actually have a will, which then states, because you can appoint all of your spouses as beneficiaries in your estate. So if you do have more than one spouse, please take care of this. So in this particular instance, the second wife will have a claim. If, however, she's been ousted by the first wife, then she has the right to bring the appropriate legal action to recognize her right and claim to the husband's estate.
But now I think we're talking about death when there's a death. I think the caller might be asking, what if there's two concurrent marriages? Which one takes precedent? So again, it depends on which is the recognized civil marriage. However, our courts have gone a great way to try and move away from the old, it was actually against public policy, they used to say, in the apartheid regime, it's abhorrent to public morals to have more than one wife. So theoretically, all Islamic marriages were excluded. But now there's a reality in that, and the courts are very, very aware of the fact that a man, according to his conviction, may have more than one wife.
Absolutely.
And there is a jurisprudential development in that regard.
Yes, there certainly has been, because as Ashraf had said initially, if you were married only by Islamic rights and you took a second wife, because that marriage was potentially polygamous, it was not recognized by the law. But now certainly in terms of the strides, in terms of our constitution, these rights are being entrenched. So I think that if anybody finds himself in this particular position, then they would have recourse. Now, if a person is married to two spouses, in terms of the law, neither one of the marriages takes precedence. However, people also need to understand that if you get married to more than one spouse, that you also develop the duty of support to more than one wife, and also to her and to any children that may be born from her marriage. So, in as far as your obligations are concerned, certainly that those are also very much extended. So, in as much as you may have the pleasure of two wives, you also need the pocket to be able to look after the two wives.
So what you're saying that both the spouses, both the wives and their children will have an equal claim for maintenance. You can't maintain one and exclude the other. You've got to do it fairly.
Absolutely. Well, I mean, again, that's now from a Shariat position. The obligation is that your duties extend to all your wives and children equally. Obviously, from a South African point of view, that is about the same position where they would have recourse against you in terms of the fact that you are either the spouse or the parent.
Okay. I hope that answers your question. Now, we come to the situation where you're in court and you get a decree of divorce. Now, what should one ensure is part of the decree, especially where there's children involved?
Now, when people get divorced, again, if you have an attorney and if the matter becomes resolved between the parties in the sense that the people agree on issues like the proprietary consequences, if they agree on issues of maintenance, and they agree on issues of having rights of contact with the children, there's an act which was passed recently. It's called the Children's Act, which is a very wide and extensive act, which really goes to great extents to protect the interests of children. So in terms of the law now, parents both have joint rights in parental rights and responsibilities, which means that both parents are equally responsible for the welfare and care of the children. Upon divorce, we then speak of where the children then live with one parent. We then speak of primary residence, and the other parent would have rights of contact. So these are all aspects and consequences that flow from a divorce.
What's co-parental rights or co-primary residence? Well, there seems to be a movement by the courts towards awarding both parents the right to have like a physical custody over the child.
Yes. Now, again, depending on the circumstances of the child, if the parties agree, it is possible for the children to live for some of the time with the one parent, and other times with the other parent. However, in most cases, one finds that this is quite impractical, having regard to the fact, especially where the kids are going to school or madrasa, and depending also on the logistical issues surrounding their travel to and from. So, in most cases, it ends up where there can be, in terms of the Children's Act, when one speaks of co-parental rights and responsibilities, both parents' rights are entrenched in respect of the children. However, in terms of the day-to-day care, we speak of primary residence where the kids live with one parent during the week, for example, and then the other parent would have rights of visitation, and those are now called rights of contact. So those normally from a legal point of view are normally exercised every alternate weekend, and then school holidays are shared, and other important days on the calendar like birthdays, Eid days, those are also then shared between the parties, or they alternated between the parties. So when you're getting divorced, it's important that when you are negotiating a settlement of your divorce, that you take cognizance of all of these facts, because once these facts are agreed upon and made an order of court, they then those rights are then entrenched, and if there is any variation or non-performance, you then have recourse against the other party.
Now, there's an ancillary question that often arises. What is sleepover? You know, everyone demands, like, you know, the child should have a sleepover right. Now, at what stage does the court recognize, okay, this child can be allowed to sleep over at the other parent's home?
This is also kind of a factual inquiry, and a lot depends on the relationship that has been established between the parent and the child. If, for example, the father was a person who was very hands-on with the child and has developed a very close bond with the child, and he played a very important role in taking care and nurturing of the child, then notwithstanding the age, you know, it's very possible that even at a very young age, the court will allow him to have the child on an overnight basis, because he'll be able to take care of, you know, of that particular child.
Right. Now, on the same topic of children, I think the one caveat we have to stress is the courts are loath to listen to how bad the other spouse was. You know, you come and you say he or she is like this, but at the same time they're minor children. The court says, look, adults, you don't have to get on, but for the sake of the child, you have to get on. So it's very important just to give the viewers some advice on how to look after the interests of the child, because the theory is that the court is the upper guardian of all minor children.
Yeah, that's absolutely true. The court is regarded as being the uppermost guardian of all children. So in a divorce situation, the primary concern of the court is the best interest and welfare of the children. So yes, it does happen that sometimes there's much acrimony between the spouses, but ultimately one needs to act in that way which is in the best interest, and that is going to secure the best future for your children. So therefore, even if you can't communicate about any other aspects, it's important that you reach proper agreement regarding the issues of the children, where they would stay, what arrangements are going to be made for their education, for their transport, for their clothing, for their health care. And there has to be an open door policy between the parents to always be willing to speak about that which is going to be best for their children.
I mean, just on the final note, even if you don't agree, the court will be guided by the report of the Family Advocate's Office, and the Family Advocate's Office will employ professionals to draw a report. So at the end of the day, an assessment will be made. Is that right?
Absolutely. I think that, you know, because of the great care that and concern that courts have for children, we have this institution of the Office of the Family Advocate, and if there is any issue or any issues that parents themselves cannot resolve, or if there is any issues that the court may feel needs to be resolved, the court can refer the matter to the family advocate, who will then do an investigation via legal-minded people, as well as through social workers, and they will then try and reach a conclusion that is in the best interest of the children.
And on that note, unfortunately, we've run out of time. We thank you for joining us this evening and for your questions, and I take the opportunity of thanking my guest, Attorney Mahmood. And if you have any questions, please get in touch with him. But thank you very much once again. Assalamu alaikum wa rahmatullahi wa barakatuh.